Hello there. This is An Architect Goes to Law School. Today we'll start a new class, Civil Procedure. Civil procedure is the portion of legal proceedings that ensures fair trials in coordination with the substantive portions of the proceedings, the legal claims, and the evidence. Civil procedure in the American court system includes two different roles acting in concert throughout the civil trial process. The first role is that of trier of law, with the second being trier or finder of fact. The judge in a civil trial is always the trier of law, like a referee. The trier of law's role throughout a trial is to ensure civil procedure is being followed properly by all parties. They oversee initial pleadings, rule on motions both pre-trial and during the trial, and make a final judgment in the case. The trier of fact role is different in that it can be filled by a jury or the judge. Once a trier of fact is selected, they'll make decisions on the value of the evidence and testimony given at trial, weighing its importance and veracity. In a jury trial, the jury will make certain decisions, and it's up to the judge to render a final judgment based upon those decisions. Procedural due process is the portion of civil procedure that requires all parties who can reasonably be expected to participate in a specific lawsuit to have fair warning of the litigation. Furthermore, all actual parties to a lawsuit are accorded notification of the activities that occur throughout the suit. Possibly more importantly, due process also requires the litigants be given the opportunity to be heard in the court proceedings. These requirements placed on the government, which in civil litigation is the conduit for actions between private parties, come from two amendments to the U.S. Constitution. Federal courts have due process requirements via the Fifth Amendment, and state courts have due process requirements via the 14th. The Due Process Clause of Section 1 of the 14th Amendment reads in part, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law," end quote. Because of statutes, administrative procedures, and court cases, federal and state courts are required to provide notice about a court case's activities, as well as the chance to participate to the litigants. These procedural measures have been put in place so that, quote, "deprivation of life, liberty, or property by adjudication be preceded by notice and opportunity for hearing appropriate to the nature of the case," end quote. One of the major components of procedural due process is notice. The importance of notice first arises when a party is to be made aware of the initial pleadings. This is called service of process, and people who deliver such documents directly to litigation defendants are called process servers. Additional times in a suit when notice matters are when parties must be warned of upcoming trial events, such as hearings on motions, deadlines for discovery, and the trial setting. These notices are important because they directly relate to the second component of procedural due process, the opportunity to be heard. Litigation is not about surprises, despite many media representations to that effect. Due process is about fairness in stating a claim or mounting a defense in dispute resolution processes. Hearings are scheduled so that the attorneys can all be present and represent their clients' interests. All parties must be made aware of upcoming hearings and court proceedings. Discovery documents are shared between the adverse parties. Depositions are attended by attorneys for all the various parties to the suit. All of this procedural due process is meant to ensure proper notice and an opportunity to be heard. In federal courts, the rules for notice are controlled by the Federal Rules of Civil Procedure, FRCP. Each state has its own set of rules for civil procedure and should be consulted for litigation in state courts. FRCP 4, summons, is where we find the process for serving a complaint on defendants. Complaint is the federal term for the initial pleading. This rule covers such topics as the complaint's contents, how to perform service on defendants of various kinds, such as an individual, a company, or governmental agencies, and how to prove service was effected properly. FRCP 5, serving and filing pleadings and other papers, similarly covers when service is required, how it must be made, and filing those documents with the court. FRCP 6, Computing and Extending Time, Time for Motion Papers, defines how to calculate calendar deadlines for certain events. It's a best practice, to say the least, to pay attention to the timelines in each particular instance of notice created and disseminated during litigation. Missing a deadline may result in a default judgment or a lost opportunity to respond to a motion. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll discuss statutes of limitations and repose. Thank you for watching, and Architect Goes to Law School.